All right. This is 251474FD, the people versus James Winsel.
Good morning, Your Honor. Alyssa Segura with the Neighborhood Defender Service, P86432, appearing on behalf of James Winsel, who stands to my right. Mr. Winsel, state your name.
James Winsel.
All right, and I have here a lengthy plea agreement document.
Before this courtroom exchange even begins, the case already carries serious consequences. A man named James Winsel is standing before the judge facing a drunk driving case that could potentially lead to jail time. But there's a twist. Instead of going to trial, the court is reviewing a detailed plea agreement that could dramatically change the outcome. It involves probation, treatment court, restitution for damages, and strict conditions that could send him straight to jail if he fails. Now here's where things get interesting. The judge is about to walk through every detail of this agreement, and the numbers, the conditions, and the defendant's own admissions will reveal just how serious the situation really is. The question is, will this plea deal give him a second chance, or set him up for even bigger consequences down the road?
I'm just going to read it into the record.
That's fine.
Okay. The defendant will enter pleas to operating while intoxicated second as charged with the sentencing agreement of 60 to 90 days jail as determined by the judge with work release if eligible and available. The jail condition may be waived at the discretion of the court if the defendant completes a specialty court program pursuant to MCL 257625-9 parent B and or parent C. The OWI3 charge will be dismissed at sentencing provided the terms of the agreement are satisfied. 2 years probation with treatment court. No early termination from probation, any scale approved treatment court or specialty court. If I'm taking the plea, he'll be assessed here. In addition, all other terms set by the court, costs of prosecution, alcohol and drug treatment and screening, full restitution for any out-of-pocket costs or damages harm incurred as a result of the offense, honored before sentencing if applicable, minimum of $800 for damage repairs to the other driver. If the restitution is not paid in full by sentencing, then the offer can be set aside. If the defendant fails out of sobriety court or specialty court due to poor performance or commits another crime while on probation, or if the judge finds sufficient cause to terminate probation, then the balance of the year must be served in jail, no work release or waiver. The defendant will stipulate that to the sentencing agreement and the OWI third offense are sufficient grounds for incarceration if it's imposed. The defendant will need to acknowledge 2 prior OWI convictions to support the plea, and the offer is only available when the case is pending in the district court and must be accepted by the judge. Is that all accurate?
Yes, Judge.
Sir, did you understand everything I just said?
Yes.
All right, and have you had a chance to go over it with Ms. Segura?
Yes.
And is it your desire to enter into that agreement?
Yes.
Mr. Winsel, you know it's a tough program. The treatment court program. You understand that? Okay. So the plea will be contingent on all of the terms that were written there. And you understand, sir, that operating while intoxicated second offense is a misdemeanor. You understand that?
Yes.
Stories on the way up.
Sorry, I'm trying to find all the paperwork on this. You understand you can get up to 1 year in jail. That's a statutory maximum. Do you understand that?
Yeah.
Fine of up to $1,000 plus court costs, statutory fees. You understand that? And sir, did you go over your constitutional rights with your attorney? Ms. Segar, I have an advice rights one. If you could just take a second, go over that with him. She can approach, yeah. And I'm gonna pass this and call one of Mr. Gizicki's cases while you go over that. And then we'll get back on to put the plea in, okay? All right. Mr. Gizicki, thank you. All right, and sir, did you go over your constitutional rights outlined on this advice of rights form? Loud and clear. You have to say yes loud.
Yes.
Okay, because she's got to take everything down, okay? She has to take it down. All right, and you understand, sir, that if you accept this plea deal, you'll be waiving the trial rights listed on this form. There will be no trial of any kind.
Yes,
And you understand if you're currently on probation or parole and you enter a plea of guilty, it could be a violation of your conditions.
yes,
And do you understand that if you're not a citizen of the United States and you enter a plea of guilty, it could have immigration consequences up to deportation?
yes,
All right, and this is a plea to, let me check and see which count it is.
I think it would be a reduced count.
Yeah, I saw the. It says plea to operating while intoxicated 2 is charged. Well, he's charged with the third offense, so I'm assuming it's the count.
A reduced count of count 1, a reduction of count 1.
Or would it be
An added count.
an amended count? Because she wanted to, hold on one second, let me see, because this says on.
It says dismissed
The
count.
OWI 3 charge will be dismissed at sentencing,
Yeah,
so it must be count 1 is a reduction. She doesn't specifically say which one's amended, but
okay. Because count 2 is operating with high BAC, correct?
no, count. What's a third offense notice? Count 1 is the high BAC third offense notice. Count 2 is the OWI third offense.
Okay.
So maybe it's the count 2.
Okay.
Okay. Plea to count 2 amended. Are you waiving any objections to having the complaint amended?
No, Judge.
And I'm just going to write the remaining counts will be dismissed at time of sentencing.
Okay.
All right, and so you've had the chance to go over all of these terms with your attorney, correct?
yes,
All right, and knowing all of that, how do you plead to the charge of operating while intoxicated second offense?
guilty,
Has anyone forced you to get you to plea? Has anyone promised you anything other than the plea agreement to get you to plea?
no,
Are you pleading guilty of your own free will?
yes,
Sir, were you in the city of Taylor back on September 28th
yes,
of 2024?
yes. Yes, Your Honor.
All right, hold on one second, because it says there complainants and I just want to make sure of that. All right, and before you were operating that, and this was in the area of Party and Ecorse Road in the city of Taylor,
Yes,
and before operating that motor vehicle, had you had something to drink?
I had a few beers from a going away party from a
You just
coworker.
had a few beers? What's a few to you?
I don't even remember how many it was, to be honest with you.
Like a few was not 2 and 3, right?
No,
It was much more than 2 or 3 beers.
and yeah, plus I was on some medication from surgery for my leg.
All right, well, the medication, it looks like the stop happened or is alleged to have happened at what time? let's see.
I think 11:59, they were called to the scene, Judge.
Yeah, so they come to the scene, yeah, at 11:58. And a blood draw was alleged to have been taken at 2:29 a.m. So that's 2.5 hours later, right? Or is that, no, it's 2.5.
Yeah, 2.5, yeah.
All right, 2.5 hours later, and there was a blood alcohol level at that time of alleged 0.289. Would you stipulate to that?
I would, Judge.
All right, so that's more than a few beers. That's a lot of beers, right? Right, sir?
Yes,
Okay, and did that alcohol affect your ability to operate the motor vehicle?
yes,
How so?
by ending up in an accident, which I'm truly sorry for.
You got in a car accident?
Yes,
All right. And would you have not have done that, had you not been drinking?
no, I would have never been in an accident if I wouldn't have been drinking.
All right. Are you satisfied with what, wait, do you have a prior convictions for, drug or alcohol related offenses?
Yes,
2 prior drunk drivings?
yes,
All right, did you have a prior drunk driving, on or about July 25th of 2008 at the 36th District Court in
yes,
Detroit?
yes,
And did you have another operating under the influence of liquor on or about November 28th of 2024?
And 4.
I'm sorry, 2004.
yes.
Okay. Okay. Anything else?
No,
Are you satisfied?
I am satisfied, Judge.
All right. I'll accept the plea as knowing and voluntarily given. So Mr. Winsel, you're gonna go downstairs to probation. So go downstairs, go to your right and see if they can set up your interview with them, an assessment to see if you qualify for treatment court, okay?
Okay, thank you.
All right, and we'll get a sentencing date once we know how it goes.
Okay.
All right, you're
Thank
all
you so much,
set.
Judge.
Thank you. I have all these other files, but I don't know.
And just like that, the judge accepts the plea as knowing and voluntary. That means the court believes the defendant understands the consequences and is admitting to the offense. But the case isn't fully over yet. The next step is a probation assessment to see if he qualifies for treatment court. If he completes the program successfully, he may avoid jail. If he fails or violates probation, jail time could quickly follow. Cases like this show how courts try to balance accountability with rehabilitation, especially in repeat DUI cases. What do you think? Should treatment programs be offered to repeat offenders, or should the penalties be stricter? Let us know in the comments. And if you found this courtroom breakdown interesting, don't forget to like, share, and subscribe for more real courtroom stories.